Welcome to the, I think, third Charles Smith Memorial Lecture. This is one of the Brodies Environmental Lecture Series. It's named after a partner of Brodies who was at the forefront of this lecture series going way back to the beginning in the early 1990s. Very sadly passed away a few years ago, and we thought it was appropriate that we remembered him for the contribution he made to this lecture series and the contribution he made at Brodies as well. So thank you for coming. We have a fantastic speaker for tonight's Charles Smith lecture, Eloise Scotford from University College London, Professor of Environmental Law, and she is speaking on a topic that is very timely, both across the UK as a whole, but particularly in Scotland, in light of the Scottish Government's consultation that was launched a matter of days ago almost. And without further ado, I will hand over.
Thank you very much, James. So yes, as James says, this lecture, which I had to decide this topic not last week, but some time ago, is about an environmental phenomenon du jour. Now, as James said, very du jour in this particular jurisdiction in light of the Scottish Government's publication of its consultation on environmental principles and governance in Scotland last week. And also in Westminster, there is, working its way through currently parliamentary scrutiny, a draft bill on environmental principles and governance. So we have the spectre of environmental principles becoming part of the law of the United Kingdom happening as we speak. But principles have, in fact, been a hot topic in environmental law for longer than this, for a while now, particularly in EU environmental law, but also globally. And their moment starting to come in different bodies of UK law is not actually a great surprise. In this lecture, what I want to do is to try and explore and hopefully demystify, but I may or may not be successful in that, some of the kind of the rhetorical aura around environmental principles, and to think about their potential roles and their legal reception in the United Kingdom at this kind of pivotal legal constitutional moment for UK environmental law. So that's the ambition, quite a big ambition. But before I get into that, a brief word on kind of my background in relation to environmental principles, for those of you who don't know anything about me or what I've done. I approach thinking about environmental principles and their role in environmental law in two ways. Firstly, after a lengthy period of scholarly reflection, which I was just saying to James, there was a point at which I never wanted to think about principles again, because I wrote my doctorate on environmental principles. I've written a book about environmental principles in environmental law, and I've had to continue to write and research about environmental principles as part of my academic research. And that's partly because in addition, for the last 2 months, and Colin, who's sitting here, knows all about this as well, I have been involved in a kind of a more fast-paced engagement with the government at Westminster about what principles might look like in the future of English/UK, which is what we now have to call it at Westminster, English/UK environmental law post-Brexit, if and when our EU exit happens, in the context of that UK English draft bill. But both perspectives, that kind of the deep scholarly work and the perspective driven by kind of rapid policy engagement, both highlight a common theme, which is the kind of, there are fundamental conceptual struggles and tensions around the idea of environmental principles as legal phenomena. And I think that's kind of the big takeaway message that I want to try and make today, that embracing environmental principles in the UK is as much a conceptual challenge for these jurisdictions as a drafting or a political challenge. And I hope to show you now how environmental principles are both kind of deeply attractive ideas for environmental law, but also complete minefields for legal analysis, which is hence the topic of my talk. So I'm going to cover kind of 3 broad issues in the lecture in thinking about environmental principles and UK environmental law. Firstly, I'm going to spend some time investigating environmental principles as legal phenomena generally. Why have they become popular as legal ideas? What, if anything, can we say about their legal character in a general sense? So that will be the first thing I do. Secondly, I will try and identify the legal roles that environmental principles have taken on in EU environmental law, and the reason for doing that is that trying to understand what we're concerned about when we speak of, as the Scottish consultation document refers to it, the loss of legal force for EU environmental principles on EU exit. What do we mean by that legal force in EU law? And then finally, some reflections on the role and the future of environmental principles in UK law, in new legislation and beyond. So that's the plan. Firstly, then, what is the legal phenomenon of environmental principle? That's what I'm going to try and ask. And the first, I'm going to tell you lots of reasons why it's very hard to identify what an environmental principle is, let alone what it might be legally. Because there's a long list, and this is just a nice picture to get put it in a different format, of the kinds of things that are referred to as environmental principles in lots of different contexts. Some of them, and I've put in the kind of slightly bigger text or font, the ones that people tend to talk about more often or be more familiar with, but these, and this is not the full list, they range from things like the precautionary principle, the polluter pays principle, to the resilience principle, which is kind of starting to have a bit of purchase in various policy debates globally, inter- and intra-generational equity, proximity prevention. You probably all recognise some of these from both policy debates, legal documents, different legal systems. There's no magic about whether something gets given the name principle or not. But in general, what we can say about this kind of cluster of so-called principles is they are primarily policy ideas concerning how environmental protection or sustainable development, which may not be the same thing, ought to be pursued. So that's kind of the starting point. We know that about these principles. However, and this is where the caveats start to come in, there is no definitive or universal catalogue of environmental principles. The 1992 Rio Declaration is often cited as a starting point as a prominent list of kind of environmental principles. It's a starting point of it being kind of a strong idea of a soft law catalogue of environmental principles, but even there are some things that are listed as principles in the Rio Declaration that we wouldn't otherwise identify as environmental principles that are getting some kind of legal traction. Some of the things are very aspirational. Some of the principles in Rio are actually principles of customary international law. Some are more about rights. So it's kind of a mixed bag of things that are in the Rio Declaration. And then there are other catalogues and lists of environmental principles in different fora which contain different principles. So intragenerational equity, rectification at source, resilience, these things are not in the Rio Declaration. Some of you may be familiar with the draft, what's called the Draft Global Pact for the Environment, which was drafted in 2017, kind of the latest effort at the international level to have some kind of treaty of agreeing fundamental environmental goals with another suite of environmental principles contained therein, along with environmental rights. So there's no universal catalogue, but they're kind of everywhere. They're also open-ended in their formulation, and that's quite important in thinking about their potential legal effects. They give rise to definitional ambiguity. They're also easier for everyone to agree on. But the precautionary principle, to take a well-known example, is notoriously difficult to define, and this muddies debates over its virtues in policymaking, because it might give a reason to stamp out innovation and one extreme kind of definition of the precautionary principle, or it might just refer to taking a robust approach to the evaluation of environmental and public health risk, or it might suggest something different altogether. But this idea of this kind of definitional ambiguity is inherent in the nature of environmental principles. Further, there is this danger in talking about environmental principles that we're talking about a single category, but we're not. These are conceptually quite different, very different kinds of ideas. Some of these are polluter-pays principles started as a kind of an economic idea. Some of the ideas are about procedural guarantees. Some of them are about decision-making approaches. Some are more purely just about what kind of environmental regulation approach we want to take. We want to take a preventive approach. So they're kind of different kinds of ideas, all cast as principles. They are not conceptually equivalent. And finally, and getting now to the legal kind of dimension of them, they do not have, and this is important, it might seem obvious, but it's important to state at the outset, they do not have any kind of pre-programmed legal identities, because they're generally expressed ideas of policy. They have no firm jurisprudential foundation or tradition as universal legal ideas. They're quite different from something like human rights, for example. Although there is a big push for kind of universalism around principles underlying a lot of the enthusiasm for them in environmental law. Despite these limitations, which make them feel like not very good candidates for anything legal at all, environmental principles are having a high profile in environmental law globally. The idea of environmental principles really captivates, and a huge amount of legal and environmental policy hope is placed in them, and many vibrant bodies of law have been developing around them. So let's try and unpack that mysterious development. So this is a sense of the kind of many areas in which legal developments about environmental principles have been happening. They are not formal principles of public international law in any way. They're not customary, well, prevention you could probably say is customary international law, maybe some bits of sustainable development, but as that big map you just saw, those are not norms of customary international law on the whole. There is, however, a proliferation of soft law agreements that often use environmental principles as a vehicle of agreement. In addition, and they're the two that I've just mentioned, regional law, national law puts principles into law. So we'll talk about the treaty, the TFEU, and how that has put environmental principles into law there. The EU Charter in Article 37 starts to put some, and that's an interesting thing about what's the role of environmental principles in that primarily human rights document. National legislation, we don't have it yet, but national legislation in other jurisdictions. In Australian law, there's lots of statute which has ESD principles, principles of ecologically sustainable development. Beyond that, we have judgments, case law developing, relying, using, involving environmental principles in lots of different kinds of ways in different jurisdictions around the world, including with some kind of judicial dialogue going on, talking across different jurisdictions. They use the precautionary principle to do that. This is what we're going to do with it, and so on. We can talk about those connections if you want to, but that's not really going to be the focus of my lecture this evening. And last but not least, there is a mountain of environmental law scholarship that is very, very into environmental principles, which I've spent a lot of time trying to get my head around. But you can't say that there isn't something going on with environmental principles in environmental law. Just on, if people are interested, I'll give you just a little highlight of what's going on in other jurisdictions in terms of reasoning by the courts. Some of the systems of courts where interesting things are going on with environmental principles and are developing quite advanced kind of bodies of jurisprudence around environmental principles include Indian law is a very famous example. There, the role of environmental principles is really based on constitutional interpretation and wide remedial powers and creativity on the part of the courts. Australian law, as I mentioned, but that's the role of environmental principles in the reasoning of the courts there is very different again. It's based on widespread statutory incorporation of these ESD principles. EU law, and we'll talk about that, has a very deep body of judicial reasoning involving environmental principles. Brazilian law, just to throw in a completely other random example, also has something really, an interesting body of law that has developed around the precautionary principle in a different legal tradition again. So these examples show that there is this kind of trend, global trend of legalising environmental principles, but that the experiences are quite different across these different legal contexts. So what is the reason for this legal proliferation of environmental principles and the legal hope that is being placed in them, particularly by environmental law scholars or those who are signing up to them in soft law agreements? Well, there's a mixture of reasons of this kind of popularity of principles in environmental law. And I'm going to kind of try and unpack those reasons because I think that seeing these reasons as clearly as we can helps a little bit to clear the mist in appreciating what we might be expecting of environmental principles if we're thinking about bringing them into our own jurisdiction. And whether our expectations are a kind of a sensible starting point or not. So I've got these in kind of two broad categories, environmental policy reasons and environmental law reasons. So there are environmental policy reasons for the enthusiasm or popularity of environmental principles in environmental law. This is particularly seen in environmental law scholarship, and it's also seen in political arguments and movements supporting the entrenchment of environmental principles through legal means, which is what we're seeing happening now in the United Kingdom. So, this first kind of idea of entrenching an environmental policy vision through legal structures, or more hopefully in some kind of ways of writing about environmental principles in environmental law scholarship, there is this kind of drive that environmental outcomes might be ensured through the kind of the sheer normative force of law. If we put these things that say something about environmental protection, we put them in law, that's going to make environmental protection more likely to happen. So there is this drive for normativity of environmental principles because of the gap between what's often political rhetoric around environmental protection and practical action, or the risk of that kind of gap developing through changing political fortunes, which I think is what we're seeing at the moment in the United Kingdom. This kind of view and this hope for environmental principles puts a lot of expectation on law instrumentally. Explains the powerful rhetorical force of environmental principles in political debates, and why I'm going to be speaking to the Environmental Audit Committee about them next Wednesday. There is this kind of strong, and why these consultations and bills are happening. Environmental principles feel like something really, really important when we're worried about environmental protection standards. This kind of legal hope, however, does risk glossing over the legal and administrative complexities of implementing an environmental policy vision through law. And these complexities are what are now biting as we try and draft these statutes, or at least come up with an idea of a statute through the Scottish consultation at the moment, in trying to incorporate these generally stated environmental principles. And kind of a next step on from this, kind of the reason for the popularity of these principles related to this is that, and you see this particularly amongst environmental law scholars, is that idea that environmental principles can act as a legal link between ideal environmental outcomes and more concrete legal rules. So quite a few scholars kind of build this kind of argument that innovative legal strategies, such as environmental principles, are needed to generate a paradigm shift of behaviour within society towards goals of environmental protection, sustainability, and so on. So Ben Bohr, Jonathan Dreschuren, Klaus Bosselmann, kind of all in this school of thinking about changing the way our law is and works so that we can put a more environmental protection paradigm shift in motion. And in this kind of understanding, environmental principles are a legal middle ground that is important in relation to the complexity, the interdisciplinarity, and maybe even the kind of the postmodern times, if you take de Sadelier's approach of environmental law in the face of current environmental problems. This perspective, again, is quite instrumental, but it is helpful, at least, in contrasting these environmental principles from concrete legal rules, from binding legal rules. They are something different. So then environmental law, there are kind of a different set of reasons for the popularity of environmental principles in environmental law, and I'm calling these environmental law reasons. The first is pure pragmatism, and this is why they end up in soft law instruments, that people can agree around general ideas of environmental protection without having to agree on more kind of specific rules and obligations, or states in particular. Then the second kind of reason I've got up here, this drive to explain, legitimise, rationalise and potentially revolutionise the subject, is something that environmental scholars spend a lot of time kind of getting exercised about. But the way that environmental principles are often analysed in scholarship, or they have been in the past, is by trying to make environmental law look like other conventional law subjects. If environmental principles are like other kinds of legal principles that we know, whether that be general principles of EU law, or general principles of public international law, or legal principles in a Dworkinian sense, all of these different kind of familiar understandings of legal principles are drawn on to try and make sense of environmental principles. And what I see that as an attempt to try and make environmental law look like these other legal subjects, kind of legitimising it as a subject, making it more substantive, bringing with it some coherence with the reassurance, the scaffolding of our kind of pre-existing jurisprudential ideas. I'm not convinced that environmental law needs that kind of coherence drive or legitimising. I think environmental law is a different kind of subject, and I'm quite relaxed about that. But this trend is certainly reflected in these scholarly attempts. I think the risk in doing this is that you use kind of ill-fitting jurisprudential models for understanding environmental principles, and that then is another reason why we might misunderstand the legal role that environmental principles are in fact playing in different bodies of law. And finally, environmental principles are often one of the things that are relied on as a way of overcoming some of the immense methodological difficulties that are involved in researching environmental law, particularly for thinking about environmental ideas across jurisdictions. They can often be seen as a common reference point. Well, the precautionary principles in Brazil, it's also in the EU. That's the common legal point. We can start to see what's going on between these two legal systems with some kind of rigour. But I would say that's elusive and not very helpful. The reason for this is understandable, and there's certainly legal connections between environmental principles across jurisdictions, but that does not show that we're dealing with universal legal phenomena, and the temptation to think that something called the same thing is necessarily the same in different jurisdictions is deeply problematic. At their most revolutionary, environmental principles might be understood as constituting or representing environmental law as an entirely new legal order. And perhaps you see this most notably in Klaus Bosselmann's work on the principle of sustainability. We are, however, not in that legal territory with environmental principles, either globally or in any individual jurisdictional example, as far as I'm aware. So, overall, what we can see is that the phenomenon of an environmental principle is a powerful rhetorical idea reflecting a drive to elevate and prioritise the importance of environmental policy in political and legal systems, and in which a significant amount of policy and legal hope has been placed. Understanding these expectations and their limits, I think, does help in appreciating the legal reality of what is going on in specific jurisdictions. And before I get into looking at the EU, I do think we can say some general things about environmental principles as legal ideas. So returning to the legal developments that have been occurring in jurisdictions outside the United Kingdom, what kind of roles are they taking on? And I think we can draw at least three general conclusions about the legal roles that have been taken on by environmental principles about this from this global experience. The first, and I'm obviously moved by the rhetorical power of environmental principles to use kind of rhetorical language, but there we go. That they are kind of seen as being, well, they are acting as kind of totems. They're totemic, they're highly symbolic, and they're systemic. So the way they're incorporated into different political and where they have legal roles, there's something systemic about the way that they operate. And this is what I'm calling their kind of symbolic and integrating function. Their power comes from setting these symbolic overarching visions of environmental policy, and it's not mere rhetoric, it's an important part of their function in setting a vision and direction for environmental policy. The second thing that I think is going on with environmental principles when they have legal purchase in different jurisdictions is that they are given some kind of legal force or status. Now that looks different in different settings, but this is what I'm kind of referring to as their entrenchment function. They do entrench a vision for environmental policy in some kind of legal form. And they're influencing different environmental law contexts. It's come through varying roles in different legal frameworks. This might be through constitutionalisation, might be through different techniques of statutory interpretation, it might be through statutory incorporation and then interpretation, or judicial reasoning, or some combination of these kind of legalising mechanisms. This legalisation of environmental policy is both a characteristic that we see of principles, but something that's very legally complicated about them, particularly in trying to identify their precise legal identity. They're not legal rights, they're not other forms of doctrinal law with which we are readily familiar. In fact, from the research I've done, what I have shown is that they're building quite idiosyncratic bodies of doctrinal law where they are implicated in legal reasoning. But their special legal status reflects the perceived importance of entrenching a policy vision for environmental protection for the long term through legal means. There is conceptual tension through doing that, putting a policy vision into legal form. And I'll come back to this tension in the UK context. But both of these aspects, their policy identity and their legal entrenchment, do define their significant roles in environmental law. And the third thing that I think we can see is that they are, and I made this point briefly earlier, a kind of conceptual plurality defines environmental principles. They're not all the same thing. They're different kinds of ideas. So care must be taken as kind of as appraising them as a single or a common legal idea, despite kind of the allure of the environmental principle as a phenomenon. Beyond these core general characteristics of environmental principles, it must be recognised, and this is very important, that environmental principles are not universal legal phenomena. They vary in meaning, in legal and administrative application, in legal relevance across different jurisdictions. They can even vary in meaning and relevance within a single jurisdiction. And this comes back to their open textured formulation, meaning that they can take on different marginal meanings in different specific regulatory contexts. They're highly contingent in their legal roles, and they operate, therefore, through contingent and localised legal architectures. And it should be noted as well that environmental principles in their general formulation, as I've said, they're kind of open in terms of their definition, but that also means that they're quite flexible legal vessels and they're open to various kinds of legal development. And they have acted as kind of what I call legal catalysts for very different kinds of doctrinal application and innovation in different legal contexts. Now, anyone who's from the government or worried about what might happen in the courts probably hates that I've just said that, but that is what I can see in other contexts. But the overall, this kind of legal contingency of principles means that this is absolutely unsurprising and to be expected that if environmental principles, if embraced as distinct legal phenomena in the United Kingdom, will need to find their own place within the legal cultures of the United Kingdom, within Scotland, within Wales, within England, within Northern Ireland and whatever is connected across the UK. And their roles in those UK jurisdictions will depend on a range of factors in those different jurisdictions, including pre-existing legislative and constitutional frameworks, statutory drafting practices, the legal relevance of official policy, if environmental principles end up in a policy document, doctrinal traditions, the jurisdiction, the reasoning style, the culture of the courts that might have to answer questions about environmental principles, access to the courts, administrative practices relating to the application of principles, and so on. All of these things produce a setting in which whatever the legal kind of future identity of environmental principles may be will play out over time. But part of this kind of localising legal architecture for what might happen in the UK is the UK's constitutional history, and I'm sad to say it is history as a member of the European Union. Since EU principles have developed very specific and significant legal roles in that context. So that is what I'm going to look at now. In EU law, we can see that all the general characteristics about environmental principles that I just mentioned at play, they are totemic and systemic. They are there in the treaty, unqualified, undefined, as the legal basis for environmental policy. And also note the scaffolding around them. So this is Article 1912, and I'm assuming most people in this room are familiar with this provision. It's not, you have to find the principles in there. It's not just a list of principles. It's also saying, the first sentence is about aiming at a high level of environmental protection. That's part of what's defining these principles and locating them in the EU treaties. And this also shows that they are policy ideas that have a very distinct legal force and status. They are in the EU treaties. But beyond the treaties, and so there's not just, and this is important in Scotland, there's this and the scaffolding, and there's also this, which is currently left out of the consultation document and the continuity bill. But Article 11, which is the integration principle, and then sustainable development, which sometimes is referred to as a principle, sometimes is not. There's more of an overarching objective. So, what Article 11 does is this systematising of environmental kind of protection requirements and brings environmental principles into other areas of policy at the EU level as well. Beyond these treaty provisions, we see principles everywhere in EU law. We see them in informing legislative priorities, the polluter pays principle in the waste context. So we see principles referred to and coming alive in law, and this having these kind of specific manifestations. And then we see a whole lot of development around environmental principles in the reasoning of the European courts. both the CJEU, the ECJ before it, and the Court of First Instance and the, before it, and the General Court. So there are three main functions, and I'm conscious that time is running on, but I will get through these and then what's happening in the UK. You see environmental principles informing the interpretation by courts of legislative measures where the courts think those measures express a particular environmental principle. So, for example, specific provisions of the Environmental Liability Directive are interpreted in light of the polluter pays principle. The court adopts a teleological approach to interpreting its legislation. Now, what happens when they use principles for this kind of purposive interpretation is it opens up scope for quite creative and contested interpretation of EU legislation. And an example that I always like to use, because when I first started doing environmental law, I did waste law, and I still love waste law, but I wrote a very critical piece a long time ago now about how the definition of waste, which is interpreted in light of the precautionary and the preventive principles, is interpreted badly, because it's a particular version of the preventive and precautionary principles that is adopted by the court, and I don't think is necessarily the only way you would think about prevention, or in particular in that context. So that's the first thing that the courts do, and you see these principles through this interpretive function kind of developing quite marginal meanings in different regulatory contexts. The next thing that happens, is in the reasoning of the EU courts, and this is really hard to get your head around, and this is the thing I've been trying to discuss with some of the government officials at Westminster, and they look at me with a blank face. But I try and explain that there is a massive body of case law that is all about the courts using principles to structure administrative discretion. They have environmental principles, and particularly the precautionary principle, but there's other principles as well, are used to inform legal tests of review when acts by the European institutions, and sometimes member states acting within the scope of EU law, are tested according to various public law tests in EU law, things like informing legal basis tests, proportionality analyses, the non-discrimination test in the Cassis de Dijon doctrine, if you're thinking about an infringement of Article 34. Principles come in and they inform these tests. They're doing something in EU administrative law. And in relation to the precautionary principle, there is a really extensive body of administrative doctrine now built around the precautionary principle, partly to explain what the precautionary principle, how it should be applied, but partly generated by the principle itself. So there is this incredible catalysing kind of doctrinal developments that have happened that are about good decision-making on the basis of environmental principles. But a very important caveat in thinking about these roles of environmental principles in EU law is that it's not just a free-for-all. Someone can't just go to court and say, oh, I think this action by the Commission breached the precautionary principle. Can you tell me if it's, please quash it. The court will only get involved in evaluating actions on the basis of principles where they think that those principles were the basis of that action in the first place. So there's a kind of a constitutional limit to what the court does. It doesn't just go in and find and try and, it's not like environmental principles are fundamental rights of EU law, for example. So there is a judgment that the court has to make sometimes about whether an action was based on the precautionary principle before it starts using that principle to then evaluate whether in administrative law terms, that action was done lawfully. But these legal effects do mean that environmental principles are building a body of EU law concerning environmental policy making and decision making, entrenching an approach to environmental policy that is geared towards a high level of protection through a cascading set of legal implications that flow from these unqualified constitutional roles of environmental principles in the treaty, but which are nevertheless framed and constrained by norms of EU constitutional law. So turning to the last thing that I want to address, it's environmental principles in UK law. Now, we know that now that legal culture will ultimately determine the legal roles of environmental principles in any body of law. Now, I am not an expert in Scots law or its history, so what I'm saying now might be an English law thing, but it may have some relevance in the Scottish context. But certainly in England, there is historically has been a deep common law scepticism of policy ideas in any legal form. So Dicey, in his 1905 lectures on the relation between law and public opinion in England during the 19th century, he spoke of, and he was looking at the trend of lots of legislation around collective problems, like environmental problems. And he was very concerned about the trend of legislation of collectivism, which was threatening to the individualistic values of the common law, promoting socialistic ideas that are guided far less by force of argument than by the stress of circumstances. So this speaks to a divergence in values between the common law and statutes that regulate collective problems, like environmental problems, but it also suggests that such statutes are not based in rational argument or in some way incompatible with common law reasoning. Dworkin, writing much later, when he's looking at common law reasoning in relation to rights in his very famous 1977 work, Taking Rights Seriously, again focused on, in common law reasoning, on the rights of individuals, and he's very deliberate in contrasting legal principles from policies, which are about collective goals for the community as a whole and beyond the proper remit of the courts. Now, environmental principles are the epitome of collectivism and policy expression, and thus they do not find an easy foothold in the common law tradition. This is reflected in the very limited UK case law embracing environmental principles. There are some notable exceptions, which I can talk to about in questions if you're interested, but by and large, the UK courts shy away from any kind of argument based on environmental principles. The UK implementation of the legal impact of EU environmental principles has been purely derivative, strictly respecting their legal implications in relation to specific EU legal regimes and acts as implemented in UK law, such as the interpretive impact of the precautionary principle in the habitats regime, which is routinely applied in planning decisions, for example. Despite this, we are now faced with retaining the legal force of environmental principles in UK law under the idea of retained EU law. What does this mean? And this is where we are. We've got this bill that I mentioned at the beginning in Westminster. We already have an act in the United Kingdom, the Welsh Wellbeing of Future Generations Act, which is really into principles. So that's one manifestation, very much a manifestation of the Welsh legal culture. And then we have your wonderful consultation from last Friday. So these various attempts are on foot to embrace environmental principles as legal ideas in statute. The Welsh Act, the draft bill, Scottish consultation. And you can add to this the EU Withdrawal Act and the Continuity Bill in Scotland. So Dicey's fear of socialist collectivist legislation created in stressful circumstances is alive and well. But are they retaining, these proposals, the legal force of environmental principles from EU law, which is the instruction of these withdrawal acts? The short answer is no. I mean, we could stop there if you like, but I'll give you a little bit of a reason why they're not. And I think the reason why they're not, the Welsh Act predates, obviously, withdrawal. It's the most legally innovative model of integrating a systemic sustainable development principle through the form of wellbeing goals and objectives, which must be respected through all public decision-making. But this sustainable development framework now has to find a way to sit alongside any retention of EU environmental principles and their legal implications. And we know that Welsh academics and government lawyers are worried about how that's going to work. The English UK draft bill and the Scottish consultation propose stripping environmental principles of much of their legal force by imposing a duty on ministers only to have regard to certain principles in policy making and in developing legislation, accompanied by a policy statement to guide how the principles should be interpreted and applied. In the UK English draft bill, there are multiple exceptions and carve-outs limiting the scope of policy application of the principles, including when their implementation will require disproportionate action in relation to the envisaged environmental benefit. In the Scottish consultation, there is no mention of the integration principle. Only the four principles in Article 1912 are retained, but without the high level of protection kind of scaffold. And there is a distinct resistance to prioritising or entrenching environmental policy in the mix with other policy concerns, so in the Scottish consultation document. The interactions between environmental policy and other areas of policy are for the executive to reconcile, and ultimately government is held accountable for its policies. That's where the law comes in. Whatever you might think of the merits of this position, it's not the same as the constitutionalised priority of environmental principles, including the integration principle in EU law. Further, both the English, UK and Scottish proposals seem to assume, which I think is quite interesting, that environmental principles in statute will be a legal charter for communities resisting proposals which they believe are environmentally harmful. That is a quote from the Scottish consultation document. What's interesting is it comes back to this, what the hope and expectations that people have about environmental principles. There's a certain kind of expectation about what environmental principles are going to do in that comment. But this is not the role that environmental principles have had in EU law, where legal challenges have been much more based on interpreting environmental legislation and ensuring proper administrative practice has been adopted based on environmental principles, and often at the suit of economic actors who are concerned that government action has been too precautionary. There's a tricky issue about whether a duty to have regard to environmental principles should apply at the level of individual public decisions, such as regulatory permissions, and the UK, English and Scottish approaches resist this. The understanding of the legal position seems to be that an explicit duty of this type would go beyond the current application of EU environmental principles, which generally impact at the level of policy and the design of legislation. Again, I'm quoting from the Scottish consultation, but that is not a sound analysis of EU law, which I hope I've demonstrated this evening, where many cases at the EU level do involve individual regulatory permissions. The famous Pfizer case, which says everything there is to say, you might arguably about the precautionary principle, was just that. So where are we? And I'm not going to go through this because I know I'm taking too long. But here is a list of kind of the emerging key issues around environmental principles. Do we have the right list? There's a big problem with making sure we distinguish them from Aarhus rights, which keep being called principles in the UK English bill, and in the Scottish consultation there's a whiff of that as well. What about other principles? I think there are really fundamental questions to ask about how you frame principles in legislation. We're kind of taking the soft option of imposing duties on ministers that are familiar in our contexts. That might not be the right place to start. Thinking about who's bound by them, what they apply to, and are these the right questions to be asking is kind of the note I want to strike. My conclusions. Post-exit UK, should it happen, presents new legal contexts for environmental principles. Relegating environmental principles to the domain of policy might be consistent with some aspects of UK legal culture, but it will lose something of our EU environmental law heritage. Environmental principles, as currently proposed in the English and Scottish contexts, buck the global trend of systemic integrating principles that entrench a vision of environmental policy across a legal and governance framework in some way. And there are reasons for that entrenchment being a good thing. Which we can talk about in discussion if you'd like to. But ultimately, in this debate about principles, what we need to decide is what is our long-term UK, English, Scottish, Northern Ireland, Welsh vision of environmental protection post-exit. In Wales and Scotland, this vision might be subsumed into the broad integrating framework of sustainable development, which has both opportunities and, I would say, distinct risks for environmental protection. But even more ultimately, the legal implications of environmental principles, even if framed purely in a policy document which informs a mild ministerial duty, will fall to be decided through policy-making practice, oversight by any new environmental body that we have, and any legal arguments that might be made in any potential, but looking increasingly unlikely, judicial review actions that might be brought and, on the basis of environmental principles in some way. In light of that, and to return to the topic of the lecture, I vote that environmental principles do indeed present a legal minefield for the time being. To find some direction, though, in this complex legal moment, I wanted to finish by returning to another 19th century jurist, Henry Maine, and his 1861 work, Ancient Law, when he was grappling a bit earlier than Dicey with the stretched legislative capacity of Parliament to deal with contemporary expectations, not unlike today. He noted that social necessities and social opinion are always more or less in advance of the law. We may come indefinitely near to closing the gap between them, but it has a perpetual tendency to reopen. Right now, with the combined demands of Brexit and social pressures of environmental problems, we are at a moment where the social necessities and the development of a stable body of law to accommodate these are indeed creating a legal void in which we are really struggling to maintain clear vision. Thank you.